Today's topic of discussion will be family law, and in particular, we will talk about divorce and dissolution of civil partnership. Before we move to the topic itself and analyze the main principles around this topic, it should be useful to revise what is problem question and how to answer them. You will most probably get a problem question on this topic, so it is very important that you know the general structure and how to approach it correctly to maximize your chances of getting a first class. Firstly, you need to identify all the legal issues that are presented in your problem question. Then you need to research the relevant law, and you need to say what are the relevant cases, applicable statute, and so on. And then you need to provide application and analysis. Analysis should include the arguments that you make to convince the examiner that you understand very well this area of law and you're able to apply it to the facts of the case and advise your client. Finally, you need to make a conclusion. Conclusion is usually a sum up of your analysis and what you think would be the most likely outcome if this case that you have at hand went to the court. You may also get essay question style, which is slightly different. Here, instead of applying the law to the facts of the case, you have to refer back to the question asked and make arguments as to the question asked. Firstly, we need to discuss what is marriage. Marriage is a contract and is defined as a relationship that has a set of legal consequences established in the agreement between the two parties according to their intention. Thus, it's a formal contract that two parties enter into. As in the case of Red Matter versus Granatino, the Supreme Court gave legal weight to prenuptial contracts, suggesting an increased recognition to the idea of marriage as a contract, as people are seen to an extent to be able to decide for themselves the legal consequences of their relationship. So basically, what it means is that before marriage was basically a formal contract that the two parties were entering into, but prenuptial agreements were not allowed. However, now prenuptial agreements is more liberalized. Everyone is able to get a prenuptial agreement, which is basically deciding what will happen in case of divorce, how will the finances be allocated, and how the money between the parties will be divided. Divorce, ending in marriage is a divorce, and the divorce is the statute, the appropriate statute for divorce is Matrimonial Causes Act 1973, which is consolidated now with the Divorce Reform Act 1969. There is another reform that should be implemented actually this autumn, and make sure that you talk about this with your professor, whether or not you should include the new reform, the new act in your answers on the exam, because it's very, very new, and last year it was not included because it was not still come into force, but it was set to come into force this autumn. Make sure that you know how much you're required to write about it in your exam. According to Matrimonial Causes Act, there has to be only one ground for divorce, which is irretrievable breakdown of marriage, and at least one of the 5 facts of divorce must be present. As far as I am aware, the new act should include only the first requirement, irretrievable breakdown of marriage, and the second requirement should be annulled, but we don't know if this will come into effect for this year. So the second requirement, section 1(2), has to be either adultery and unreasonable behavior, 2 years separation with consent to the divorce decision, 5 years separation. We will discuss each of it in turn. The case of Baffery. In this case, it was held that divorce cannot be granted if none of the facts can be proved by the petitioner in section 1(2). So basically, the petitioner of the divorce has to prove with facts that either of these of these things have happened. Either the other partner committed adultery, unreasonable behavior, separation, and so on. So the facts have to be provided, the evidence to prove that either of these grounds apply. Owen versus Owens, 2018. A wife argued that her husband spoke negatively about her in front of other people, and she wanted a divorce. The Court of Appeal and Supreme Court held that the trial judge applied the law correctly. Threshold for unreasonable behavior had not been met. So as you can see, even in 2018, which was just 3 years ago, the person who wanted to get a divorce couldn't, because the facts were not, there was not enough evidence of unreasonable behavior. It could be argued that in today's time, a person who wants to get a divorce should be able to do so, and that's exactly what the new act is doing. The new act is abolishing the requirement of providing enough evidence and facts for proving unreasonable behavior or any other grounds, as long as irretrievable breakdown of marriage is shown, then the divorce has to be granted. Adultery is another ground under Matrimonial Causes Act. If another partner commits adultery, then the divorce should be granted. Section 1(2)(a) of the Matrimonial Causes Act 1973, adultery is a voluntary act of sexual intercourse with a third party of the opposite sex. As you can see, opposite sex, so it may work, works differently for same-sex couples. Dennis, in this case, it was held that adultery can only be proved if there was some penetration. So fact that the provided evidence that adultery has actually taken place, which can sometimes be challenging. What if the respondent denies adultery? That can happen. If the respondent denies adultery, it will be up to the petitioner to prove on the scale of probabilities, provide evidence that the husband or the wife has been with another person. However, Section 2(1) states that if the parties live together for more than 6 months after the adultery has been committed, the petition cannot be based on it. This is because there is a sign of forgiveness. So if the adultery is committed, that is not a straightforward ground for getting a divorce, only if the couple hasn't been living together for 6 months after the incident occurred. What is unreasonable behavior? The other ground for divorce. Unreasonable behavior can be anything that can be characterized as unreasonable. The respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. The objective test is applied, and as any right-thinking person would have acted the same way. Unreasonable behavior examples include verbal abuse, being violent, being talking to your partner in a disrespectful way, anything that is will render any right-thinking person that it's impossible to live with this person. Examples of unreasonable behavior from different cases. Kat's case. The husband developed mental health issues. He was rude to the wife in front of their children. The wife couldn't accept the abusive behavior, and she got a divorce. Livingstone versus Talbot. In this case, it was held that there must be an accumulation of trivial incidents that occurred instead of one major act. So if it happens only once, you may not be able to get a divorce. It has to happen on various occasions. Desertion. This is another ground for getting a divorce. This happens, it's under Section 1(2)(c) of the Matrimonial Causes Act. And when the respondent has deserted the petitioner from a continuous period of at least 2 years immediately preceding the presentation of the petition. So if it was for 2 years, the person hasn't been around, then there can be divorce. What are the requirements for the petitioner to be able to rely on this ground for divorce? There must be factual separation between the parties. There must be an intention by the respondent to desert. Also, there must be no consent by the petition to the desertion. So if there is a consent, then another law applies. This is the one about with consent, 2 years separation and consent, which means that if the parties have lived apart for 2 years, immediately before they filed for divorce, and there was consent for divorce, then they can get it. They should be able to get the divorce. So this is the 2 requirements together: 2 years separation, 2 years living apart, and plus consent to divorce between the parties. 5 year separation. In the case of 5 year separation, there is no need for consent. Section 1(2)(e), Matrimonial Causes Act, 5 year separation, no consent is required. If the petitioner relies on this ground, a defense is available. There was a grave financial or other hardship for the respondent. It would be wrong in all the circumstances to dissolve the marriage. So as you can see, it's not that easy to dissolve the marriage. That could explain the fact that less and less people choose to be married, unless they are sure that their relationship will last, because it's very hard to get. It's not very hard, but as you can see, there has to be some specific grounds for divorce presented, otherwise you cannot get a divorce, at least under the current law. But with the new law, this will change. And so, as you can see, even for 5 years separation, even if the couple have been separated for 5 years, there is a defense. So if the court sees that it would be wrong to dissolve the marriage, they may not grant the divorce, even if they have been separated for 5 years. Or if they see that there are any kind of hardship, the financial hardship, or other kind of hardship for the respondent, they may not grant the divorce, even if they have been separated for 5 years. There are also bars on divorce. Temporal bar, the Matrimonial Causes Act 1937 introduced a bar on divorce the first 3 years of the marriage. So in the 3 years they couldn't get a divorce, but this has changed afterwards. If you have any questions, it would be great if you put it in the chat, and I will address all the questions at the end. The Divorce Reform Act 1969 reduced the temporal bar on divorce to 1 year only. And the Matrimonial Causes Act confirms the first year ban on divorce. So under the Matrimonial Causes Act, only the first year the couple cannot get a divorce. But I think the new act is even decreasing this bar. It's not abolishing it altogether, but it's decreasing. So you make sure that you have a look at the new act if it applies for this year's exam. Dissolution of civil partnerships. Civil partnerships and dissolution will take place instead of a divorce. Usually civil partnership was a reunion for same-sex couples. So it was not, but it recently, I think it was in 2019, that it was allowed for opposite sex couple as well, because some opposite sex couples didn't want to have to be married, but they wanted to have more modern form of union, because marriage can be very traditional and it can be associated with and some status that be, for example, they don't want to be called a married couple, they don't want to have this status. So for some couples, civil partnership is a better option. So that's why it was allowed for opposite sex couples. In section 44 of the Civil Partnership Act 2004, there is one ground for dissolution of the civil partnership, which is irretrievable breakdown, exactly like it is for marriage. But for the other grounds, instead of 5 grounds for divorce, here we have 4 grounds. As you can see, there is no adultery. And why there is no adultery? Before, if you remember, if we saw that adultery has to be sexual intercourse with someone of opposite sex. So since for the Civil Partnership Act was for same-sex couple, there was no opposite sex. So that's why they took out adultery ground for dissolution. There are also the same limitations as it is for divorce. There is 1 year temporal, 1 year bar. So you cannot get the civil partnership annulled for the first year under section 1 of the Act. The petitioner cannot rely on unreasonable behavior if there is 6-month cohabitation after the Act. So the court wants the couple to try to cohabit for a bit longer before they apply for dissolution. There is a refusal of dissolution in 5-year separation cases on the grounds of grave hardship. However, this is very rarely proven. The criticism of divorce law and why it should be reformed, why it is being reformed. Firstly, it can be confusing. It is insufficient to show that a marriage is an irretrievable breakdown. It can be quite challenging if you think about it for someone who wants to get a divorce, to get evidence and facts to prove to the court that the marriage is broken down. It can be quite hard to get all this evidence, especially to prove that the partner has been with another person, the adultery was committed, or any other ground, unreasonable behavior, 2 years deception. All these grounds can be quite challenging to gather all the evidence and show it to the court and to prove that this has actually happened. And so it can be confusing. Secondly, it can be discriminatory. Couples who cannot afford separate accommodation, they cannot rely on 2-year separation ground. There are some couples who cannot just afford to live separately. So even if they wanted to get a divorce on the grounds of 2-year separation, they just haven't been together, but they are living together because they don't have any other option. They may not get a divorce under current law. And lastly, and I believe most importantly, it provides an incentive to use fault-based system. This requires one party to focus on the blame more of the conduct of the other, and it can be even more stressing. Divorce can be already quite stressing for someone, and in order to gather evidence to blame everything that has gone wrong in the marriage to your partner, that can make it even harder. So that's why the new Act is addressing all these issues, and that's why the divorce law is being reformed. A new divorce law was introduced in June 2020 by the Divorce, Dissolution and Separation Act 2020. It hasn't yet come into force. It should be coming into force in autumn 2021, but I don't have an update as to if it has come into force already and if the exams actually include this act. So make sure you ask your professor. It will depend on your university whether or not to include this. The aim is to ease the impact of unnecessary conflict on couples and their children. There is already enough conflict when they are divorcing, and the law now is promoting that conflict to find evidence for blameworthy conduct of the other. So it had to be reformed. These are the key elements of the new Act. Removal of the requirement to establish facts. Requirement to establish fault will be replaced with the option to simply make a statement of irretrievable breakdown. The statement is irretrievable breakdown will be conclusive evidence that the court must make an order for divorce. Statement of irretrievable breakdown will be able to be made by either one spouse or as a couple, as joint applications will be possible. If the other spouse does not agree to the divorce, they will not be able to contest it. So even if just one of the couples want to get a divorce, they should be able to do so. And the minimum time is different now with the new act. You should see our notes on this topic in full and have a look at all the main cases to make sure that you have all the important information for your exam on this topic to get high grade. We recommend that you use our content in addition to your lecture slides. It is very important that you review your lecture slides very carefully, because there your professor will highlight the cases and the principles that you need to use in your exam. If you do not focus on those cases that your professor has highlighted on the lecture, you may lose marks. So make sure that you review your lecture slides very carefully. And in addition to that, you review our notes. Most probably we will have all the cases that your lecture slides have in detail on our platform. So make sure that you use it. You read our case summaries and our notes. Also, we have a practice question, a problem question on this topic that you can read on this link. You will receive the slides after this session and you can have a look at these links. How can we help? At Simple Studying, we provide simple study resources focusing on getting high grades. Our team, our content creators, are top students and graduates who create simple study resources for you to get high grades, to maximize your chances of getting a first class. Our content includes simple notes, essays, tutorial videos, quizzes, flashcards, and interactive learning platforms, study groups that you can join for free. If the resources are not enough, we highly recommend you to have a look at our tutoring services. Our tutoring services is a perfect way for you to practice with us one-to-one your legal writing skills. We can attempt to answer your practice questions from past exam papers or our own practice questions to help you understand how to write problem and essay questions in order to get the highest grades possible. We help students on tutoring sessions to learn correctly how to get high grades, to create a correct study plan, to practice their legal writing, to get some guidelines on how to prepare for their exams and courseworks. So you make sure that if you're struggling and you need additional help than what we offer with our content, you have to look at our tutoring services. We have already helped thousands of students to get high grades. 90% of our regular users get your first class, as you can see on the reviews. We would love you to be our next student to get high grades. Please join Simple Studying and join our WhatsApp groups to interact with our community from here. Thank you very much for your time. If you have any questions, I'll be glad to answer now.